Good day, Crime Talk aficionados. We have another great show for you. First, we have an update on the assassination of Charlie Kirk. Should prosecutors seek the death penalty? We'll discuss. FBI arrests 2 individuals in Utah for planting an explosive device beneath a local news truck. A motion to dismiss is filed in the Courtney Clenney murder case. A New Jersey judge denies the release request for a guy that's been in custody waiting for a trial for 7 years. The resident evil guy, well, he's been turns a road rage incident into his own personal zombie apocalypse. Another teacher is investigated for, well, you know what? We have this day in legal history. Our legal quote of the day comes from a Supreme Court justice explaining the right against self-incrimination. And finally, our dumb criminal of the day. He just couldn't wait. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get started, a couple of announcements. First, go to CrimeTalkSearch.com, sign up for a background subscription service today. When you do, you'll be able to do a background search on anyone here in the United States. The amazing thing is the report is literally prepared and emailed to you while you wait, and you're going to get all types of information about this particular individual or individuals that you are searching. You're going to get their phone numbers, email addresses, social media presence. You're going to find out if they're married. Are they divorced? Do they have property? Do they have liens and judgments against that property? Do they have a criminal history, and are they on one of those registries? You know what I'm talking about. Go to CrimeTalkSearch.com. Sign up today. Information is power. Find out if you should let somebody into your life, or maybe you're not sure if they should remain in your life. Go check it out. You're going to be happy that you did. All right. The next thing. Yes, we are in casual attire today. Why? Because it is the week of judicial conference, or I should say half a week of judicial conference. So once a year here in the state of Colorado, all the judges get together and they go have a conference. That was kind of funny. Years ago, they got in conference because nobody was going to the speakers, any CLE or some sort of event on the road. They were out playing golf. And of course, it made the news. So then they said, well, we're going to have it downtown and everybody's required to come and there'll be no golf. But now I think they're back to golf. And anyway, the prosecutors all get together for their little organization. The public defenders do their little thing. And yes, us private attorneys just are out here, trying to make a buck because we don't get paid unless we actually collect the money. If you work for the state, you get a check once a month, twice a month, whether you need it or not. I guess it's good to be able to do that. Anyway, it's also important to stay up on new developments in the law, which we will be doing as well. Now, the other thing is we told you we went to CrimeCon last week. And if you came by the Crime Talk table, we gave a giveaway. I don't think we've actually mentioned what the giveaway was, but people really liked it. And so here is an example of what we gave away. Yes, a Crime Talk keychain, luggage tag, got Crime Talk on either side. Can't go wrong with it, right? Pretty cool little giveaway in my humble opinion. Anyway, guess what? We still have a few left. A couple hundred left to be exact, even though we were trying to give them all away. We didn't quite get it done. Anyway, I can't give them away to you because otherwise I have to ship them all to you. I mean, unless you want to come by the office, I guess you can get one. But what we think we were going to do, and let us know in the comments if you'd be willing to it. But, if we charge, I don't know, a couple bucks, maybe $5 plus some shipping and handling, would you all be interested in purchasing the little keychains here? If yes, we will set something up on our website. If you don't, we'll just save it for next year, but let us know because we don't want to waste your time or particularly mine as well. All right, let's go ahead and open the record for Monday, September 15th, ladies and gentlemen, September 15th. Can you believe we're halfway through September? Amazing. All right, first on the docket, the assassination of Charlie Kirk. Let's give an overview. Unless you've been under a rock, you've probably heard about what took place on September 10th. Charlie Kirk, a 31-year-old prominent activist and founder of Turning Point USA, was fatally shot during a speaking engagement at Utah Valley University in Orem, Utah. Now, the attack occurred when a single bullet struck Kirk in the neck, fired from a rooftop overlooking the event. He was pronounced dead at a nearby hospital shortly thereafter. Police recovered a high-powered bolt-action rifle, believed to be the weapon discarded in the wooded area and wrapped in a towel. Surveillance footage captured a suspect dressed in a t-shirt featuring an American flag, black shoes, sunglasses, and a black hat. The suspect, Tyler Robinson. He's 22 years old, and he's from St. George, Utah, and he was apprehended on September 12th following a brief manhunt. Like 33 hours to be exact. So Robinson is a resident of Washington County, has no prior criminal record, and was registered as being an unaffiliated voter. It also shows that he was an inactive voter, indicating that he did not participate in the 2024 presidential election. Now, he came from what is being described as a very conservative family. His father, Matt Robinson, operates a construction business specializing in kitchen installations, while his mother is a licensed social worker. Now, despite his family's political leanings, Robinson has apparently developed some contrasting views in the recent years. Now, academically, Robinson excelled in high school, achieving a 4.0 GPA, and got a 34 on the ACT, which earned him a full scholarship to Utah State University. However, he attended for only one semester in 2021 before withdrawing and enrolling in an electrical apprentice program at Dixie Technical College, where he was in his third year at the time of the incident. Now, a former classmate described him as unremarkable and socially engaged, particularly with the school's band and auto mechanics club. Now, one acquaintance characterized him as a Reddit kid, highlighting his immersion in online communities and suggesting excessive internet exposure may have influenced his actions. Now, Robinson was in a romantic relationship with his transgender roommate, a guy by the name of Lance Twigg, who is trying to transition from male to female. Now, apparently, Mr. Twiggs has cooperated fully with investigators, expressing shock upon learning of Robinson's involvement in providing access to relevant messages. Now, Robinson's arrest followed his confession to his father, who identified him from FBI-released surveillance images, and then he alerted police. When confronted, Robinson reportedly expressed a preference for suicide over surrender, prompting his father to involve a youth pastor who then contacted the United States Marshals. Now, Robinson is currently detained without bail in the Utah County Jail under special observation due to suicide concerns, and he faces initial charges of aggravated murder, felony discharge of a firearm causing serious injury, and obstruction of justice, with formal charges anticipated being filed tomorrow, September 16th. Now, officials in Utah, including the governor, Spencer Cox, and Attorney General Derek Brown, are considering a mix of state and federal prosecutions and have indicated their intent to pursue the death penalty if there is in fact a conviction. So, what do we got as far as evidence? Well, apparently some key evidence now includes DNA matches from a screwdriver found on the university rooftop and the towel encasing the rifle, both linking directly to Mr. Robinson. Now, there's text message exchanges with an associate, and that revealed Robinson's intent, stating he had an opportunity to take out Charlie Kirk due to his disdain for Kirk's views. Now, a written note, since destroyed, apparently contained similar language as well. Now, there were some post-shooting communications between Twiggs and a friend referenced a note left by Robinson. Now, online messages also mentioned concealing a rifle in bushes near the site, and the rifle casings bore engravings reflecting internet memes, anti-fascist themes, and gaming references. Hey, fascist, catch, accompanied by directional arrows, possibly alluding to anti-Nazi symbolism, or video games like Helldivers 2. Then we got the Bella Ciao, invoking an Italian anti-fascist resistance song popularized in media such as Netflix Money Heist and the game Far Cry 6. There was also engraved on one of the casings, "If you read this, you are gay." LMAO, a crude internet acronym-laden phrase. Notice bulge, OWO. What's this? This is a meme often used to mock certain online subcultures. Particularly, it means dudes that are attracted to dudes that are thinking they're no longer going to be dudes, but they still get a bulge in their pants. Anyway, Robinson has refused to cooperate with law enforcement since he's been arrested, certainly his constitutional right to do so, and he is given the presumption of innocence. But obviously, anything he said to anyone, including his dad, guess what? Statement against interest, it is not hearsay. It comes in as an admission of a party opponent at trial. So like I said, he hasn't cooperated with police. That's his right to do so. He's got attorneys. They're going to advise him to keep his mouth shut because they're probably going to try to, save his life and save him from the death penalty. Anyway, the FBI director, Kash Patel, confirmed the DNA evidence and messages during an appearance on a news program earlier this morning. So why did he do it? Well, investigators are probing Robinson's shift in ideology, which diverged from his conservative upbringing after leaving the college. Now, Governor Cox attributed this immersion to deep, dark online spaces, including Reddit and gaming communities where radical ideas are proliferated. Now, Robinson reportedly discussed his dislike for Kirk during a family dinner prior to the event. And while no direct coordination via platforms like Discord occurred, although I think there may be more coming, post-incident messages aided the probe. Now, the governor emphasized the role of the internet memification in societal polarization, noting Robinson's transformation from a high-achieving student to someone capable of such an act of murder. Now, Governor Cox has publicly detailed the investigation, stressing cooperation from Robinson's circle despite the suspect's silence. And President Trump, a friend of Kirk, addressed the incident on September 14th, asserting that the individuals traditionally on the left are under major investigation. He attributed the attack to leftist rhetoric fostering hatred, contrasting it with right-wing issues, and echoed calls for the death penalty. Now, Trump plans to attend Kirk's memorial, which will take place next Sunday. Like I said, that memorial will take place September 21st at State Farm Stadium in Glendale, Arizona. And this is organized by Turning Point USA. And the event aims to celebrate Kirk's life and legacy. And the stadium accommodates up to 73,000 people. Now, apparently there's going to be a private family service, but that has been kept quiet as to those details. Now, as of today, the investigation continues to refine evidence for forthcoming charges, and police have debunked unrelated rumors such as claims about Robinson's father working for law enforcement or a vanishing plane near the site. These cases underscore concerns over online radicalization and real-world impacts, obviously. So let's talk about potential charges. Now, police state there is no evidence as of this time of an accomplice. Now, there are lots of posts where people said something big is going to happen. Charlie Kirk is coming to my school. Things like that, where people posted it online. Something, oh, well, that's done immediately after Charlie Kirk was shot. So the police and FBI are going to be going through all of these types of communications, trying to figure out who is talking to whom and who assisted. Where did the rifle come from? Family rifle apparently was lent to him by somebody. So somebody may have had some advanced knowledge. And if they did, guess what? You could be found guilty under a complicity theory. That's right, because if you aid, assist, encourage somebody to commit an illegal act, you can be charged as a complicitor, just like you did it yourself. Anyway, initial detentions have yielded no links in the investigation, and interviewing family, friends, and the transgender roommate has not uncovered any co-conspirators as of yet. Now, speculation about the roommate stems from potential motives related to Kirk's view on gender identity, but this remains unverified. Now, if evidence emerges that others knew of the plan and failed to report it, obviously they could be charged under Utah law for obstruction of justice or accessory after the fact, punishable by up to 5 years in prison. And I assure you, those applicable Utah statutes have probably been brought up once or twice when talking with somebody that may have information about the case, because the threat of imminent incarceration tends to break the bonds of loyalty. Anyway, the family has been cooperating post-arrest, and that reduces the likelihood of charges against them. Now, the broader fallout includes fringes or individuals for online comments celebrating the killing, but these are employment actions, not criminal charges. So let's take a look at the potential charges and the death penalty. That's right. Should the prosecutors go forward on the death penalty? Usually the death penalty is saved for the worst of the worst, right? It's usually a guy with extensive criminal history. But, I know it's a different state, but look at Brian Kohberger. 4 murders. That's it, but only has to meet the statutory definition. So let's take a look at this. So Utah authorizes the death penalty solely for aggravated murder as defined under their code. And the prosecutors, if they decide to go to the death penalty, must provide a notice of intent to seek the capital punishment. Now, aggravated murder occurs when an actor intentionally or knowingly causes another death under specific aggravating circumstances, elevating the offense from standard murder, which is punishable by 15 years to life in prison, to a capital crime, which obviously includes death or the life without the possibility of parole. So the Utah Code 76-5-202(1). The homicide was committed by a person confined in a jail or correctional institution. No. The homicide was committed incident to one act, scheme, course of conduct, or criminal episode during which 2 or more persons were killed. No. Or during which the actor attempted to kill 1 or more person in addition to the victim who was killed. Nope. The actor knowingly created a great risk of death to a person other than the victim and the actor. Possibly. The homicide was committed incident to an act, scheme, course of conduct, or criminal episode during which the actor committed or attempted to commit aggravated robbery, rape of a child, object rape of a child, forcible sodomy upon a child, forcible sexual abuse of a child, aggravated sexual abuse of a child, child abuse or aggravated sexual assault, aggravated arson, aggravated burglary, aggravated kidnapping, or child kidnapping. The homicide was committed incident to one act, scheme, or course of conduct or criminal episode during which the actor committed the crime or abuse or desecration of a dead human body. No. The homicide was committed for the purpose of avoiding or preventing an arrest of the defendant or another by a peace officer acting under the color of legal authority or for the purpose of effecting the defendant or another's escape from lawful custody. No. Was the homicide committed for pecuniary gain? Don't think so. The defendant committed or engaged or employed another person to commit the homicide pursuant to an agreement or contract for remuneration or the promise of remuneration for commission of the homicide. No, don't think so yet. The actor was previously convicted of aggravated murder, attempted murder, and plethora of other bad murder crimes. No. The actor was previously convicted of aggravated assault, mayhem, kidnapping, child kidnapping, and all the other child kidnapping crimes that we had. No, because he has no criminal history. The homicide was committed for the purpose of preventing a witness from testifying. Nope, not that. Let's go on here. Was the victim victim a local, state, or federal public official or candidate for public office? And the homicide relates to that position. Nope. Charlie Kirk was a private citizen. The victim is or was a peace officer. Nope, obviously not. So those are the aggravating factors. And so if the shooter was convicted of aggravated murder in a separate penalty phase, obviously determines the sentence, and they have to weigh the aggravating factors versus the mitigators. So obviously, Robinson is intended to be charged with aggravated murder, indicating the prosecution believes at least one of the aggravating factors applies. The most relevant appears to be the actor knowingly created a great risk of death to persons other than the victim, since the shooting occurred in a crowd outdoors with over 3,000 people attending using a high-powered rifle, which could endanger bystanders through ricochet or misfire. No other factors clearly fit. Kirk was not a public official. The motive was not financial gain, and there's been no prior convictions or concurrent crimes. So if this aggravating factor holds up, the prosecutors may seek the death penalty upon filing notice, subject to obviously a conviction at trial. Now, the case remains ongoing with the motive and full evidence pending further disclosure. Now, some people have said, well, what about federal jurisdiction? Well, remember, federal jurisdiction over murder cases in the United States is generally limited, as homicide is primarily a state offense unless specific federal elements are present, such as the crime occurring on federal land, involving federal officials, or implicating interstate commerce, civil rights violations, or other statutory hooks that the feds could come in under. Anyway, in the context of the assassination of Charlie Kirk, a private citizen and a political activist, the case does not inherently fall under federal authority, and initial charges have been filed or will be filed at the state level in Utah. However, the Federal Bureau of Investigation and the ATF are actively involved in the investigation, including forensic analysts of the firearms and evidence of a motive note. And the federal participation raises the possibility of a parallel federal prosecution if evidence supports applicable statutes, particularly in connection to broader groups or interstate elements if they emerge. Now, based on the latest information available, no federal charges have been filed against the suspect, Tyler James Robinson, as of right now. Now, it remains unclear whether the case will proceed solely in state or will the federal courts pick it up as well, though FBI probes into potential ties to leftist groups in Utah suggest that additional evidence could trigger federal involvement. So let's take a look real quick. I know this is getting a little nerdy, but hopefully that's why you come here. All right. So a couple of the potential federal charges could apply, and obviously it depends on the facts of the case. But obviously, political motivated shooting at a public event, recovery of a high-powered rifle with engraved anti-fascist messages and indications of radicalization. These are obviously contingent on how the evidence comes about, such as proof of conspiracy, interstate activity, or violation of federal firearms law. But a couple of things they could be looking at. Use of a firearm in the commission of a crime of violence. The statute prohibits possessing, using, or discharging a firearm during and in or related to a federal crime of violence. And that conviction carries a minimum sentence of 5 to 10 years if the gun was discharged. Now, the underlying crime of violence must be listed by a federal offense. Here, if the assassination is linked to a federal violation, like a civil rights conspiracy, then this could possibly apply. Now, the ATF's ongoing analysis of the Mauser bolt-action rifle could reveal federal firearms violations such as an illegal modification or interstate transport in violation of federal law. That could provide a federal hook as well. However, no such details have been confirmed, and the rifle appears to be legally owned based on current reports. If a federal predicate offense is established, otherwise not applicable as the standalone murder charge, then you've got federal protected activities. I mean, this prohibits willfully injuring, intimidating, or interfering with a person by force because of their race, color, religion, or national origin, and because they are participating in certain federally protected activities, right? Like attending a public university that receives federal funds. It's always about the money. Anyway, penalties for that include up to life in prison if death results. And obviously, Utah Valley receives federal funding, potentially qualifying the event as a protected activity. However, the statute requires a discriminatory motive based on protected characteristics, race or religion, not political affiliation. And the suspect's apparent political radicalization and anti-fascist bullet engraving suggest ideology as the driver, which does not fit. Expansion of political views would require legislative change or a very novel interpretation of the law. So the likelihood, pretty low, absent evidence of qualifying discriminatory motive. Then, of course, we've got hate crimes. And under the Matthew Shepard and the James Byrd Jr. Hate Crimes Prevention Act, this criminalizes willfully causing bodily injury or attempt to cause bodily injury because of actual or perceived race, color, religion, national origin, gender, sexual orientation, gender identity, or disability. And if death results, penalties can include life imprisonment without parole. Now, political ideology or affiliation is not protected under that statute, and while the assassination appears to be politically motivated, for example, disdain of Kirk's conservative views, it doesn't align with the enumerated characteristics. And reports of the suspect's transgender roommate and potential related motive have been speculated, but they're there. But once again, probably the likelihood under that statute, little to no chance based upon the current facts. Conspiracy or group ties, right? I mean, given the FBI's investigation into leftist groups of possible connection to the suspect, the following could apply if evidence substantiates such involvement. Conspiracy against rights. 18 United States Code Section 241. This prohibits two or more persons, right? That's a conspiracy. Two or more persons conspiring to commit an illegal act from conspiring to injure, oppress, threaten, or intimidate any person in the exercise of constitutional rights. For example, free speech, freedom of assembly, the First Amendment, right? And if death results, penalties include life imprisonment or death. Now, Kirk's event involved political speech, obviously protected by the First Amendment, and evidence shows the suspect coordinated with others. Somebody on Discord, kind of encouraged him to kill Kirk due to his views. This could potentially constitute a conspiracy to deprive him of his rights. And if the investigation into leftist groups focuses on whether they provided support or had foreknowledge, which could elevate the case federally. Now, as of right now, no such links have been confirmed, and the suspect is described as a lone actor thus far. Color me skeptical of that. I don't believe in coincidences, ladies and gentlemen. Anyway, likelihood moderate to high if there is a connection of proof, but if they can't do it, obviously they're not going to bring charges if they don't think they can prove it beyond a reasonable doubt. Then you also have seditious conspiracy, 18 United States Code 2384. This criminalizes conspiring to overthrow the government, pose its authority by force, or prevent execution of its laws. 20 years up in prison. So if the assassin is framed as part of a broader effort to disrupt the political process or intimidate conservative figures and involves multiple parties, this could apply. However, targeting a private activist like Kirk may not directly oppose the authority of the government unless tied to larger aims. So once again, pretty low. Providing material to support terrorism. Section 2339A prohibits providing material support, weapons, training, knowing if it will be used for certain violent crimes as supported by designated foreign terrorist organizations. Now, this act fits the definition of domestic terrorism, violent acts intended to intimidate or coerce civilian populations or influence government policy. However, there's no standalone domestic terrorism charge. So the support statute requires ties of listed offenses in the group. Now, this is kind of what they did to Luigi Mangione, basically saying it was a terrorist act to influence the government. Not the strongest charge ever, but they were trying to get federal jurisdiction. So once again, pretty unlikely that they'll bring charges under that, unless, of course, the evidence changes. Like all things in law, you have to be able to prepare to change with new facts that come about. So the domestic terrorism designation, while the FBI may classify the incident as domestic terrorism for investigative purposes, that doesn't create a new charge, but can lead to sentencing enhancers if there's in fact a charge brought in federal court. And of course, obstruction of justice, but I don't imagine the federal government would waste their time on one little charge like this, given the fact that Mr. Richardson will be potentially facing the death penalty in state court. And that's if you destroy something, move, alter, tamper with any sort of evidence in any particular way. But once again, those charges can be brought in the state court as well. Like I said, no current federal indictment announced as of yet. But if the ties to groups are unsubstantiated, the case may remain state only, focusing on Utah's death-eligible aggravated murder statute. And obviously, this is based upon information we have now. It could change as new information becomes available. A lot of information there, I know, kind of a little geekish, but like I said, you can get the 15-second rundown on everything, but hopefully we provide you a little more information as well. Like I said, right now, it's just one guy Mr. Richardson will see charges. I think it will be televised tomorrow's court appearance. We'll try to bring that to you if it in fact is. Obviously, people are rolling on Mr. Richardson rather quickly because they don't want to go to prison. But the interesting thing is going to be, what did they find out in these online chats and things like that? If somebody was encouraging him to go do something, if they agreed to help him in some way, there could be more charges. And obviously people that came out and were happy for the death of Charlie Kirk. That is not a crime in and of itself, but as a lot of them have found out, it can also keep you from being employed. Because although you have a right to say whatever you want here in the United States, well, it's not without consequences if people say, we think you're a horrible human being and we don't want you to work here anymore, as a lot of people have found out. And I think there will be more to come. And remember, the free speech, that only prevents the government from taking action against you because of your speech, ladies and gentlemen, unless, of course, it's true hate speech or true threats. I should be more accurate. True threats. However, you don't have a First Amendment right to keep a job if your employer doesn't like what you say. So keep that in mind. Always be nice, respectful. Even if you don't mean it, just bite your tongue. As your mom used to always say, if you can't say something nice, don't say anything at all. All right, moving on. FBI arrested a couple of guys who wanted to plant a bomb. Can you believe this? So in a recent development in the Federal Bureau of Investigation, ongoing duties in Utah, they've apprehended 2 suspects following the discovery of an explosive device positioned under a car or one of those news vans for the local Fox affiliate there in Salt Lake City, Utah. The individuals have been identified as Adib Nasir, who's 58, and Adil Justice Ahmed Nasir, who's 31, and they face several serious charges, including threats of terrorism, possession of weapons of mass destruction, and possession of explosive devices. The device was detected on September 12th and confirmed to be authentic, according to reports. Police noted that it had been ignited but did not detonate excessively. These 2 knuckleheads couldn't even do that right, I guess. Man, should have called them our dumb criminal of the day if it wasn't so damn serious. Anyway, personnel from the Salt Lake City Police Bomb Squad and the Unified Fire Authority Arson Bomb Squad identified the device beneath the news vehicle, which was stationed adjacent to an inhabited structure. And court records indicate that the device's characteristic and location represented a substantial hazard to community safety. The FBI's Salt Lake City field office subsequently assumed control of the investigation since it involved things that went boom, and law enforcement linked the device to a residence located at the intersection of 2700 South and 8500 West in Magna, where the suspects both resided. Federal agents executed a search warrant at the property with the assistance of local police. During the search, police uncovered 2 simulated weapons of mass destruction, 2 firearms materials, and construction bombs and illicit substances. As a precautionary measure, neighbor residents were evacuated while the operation proceeded, which is make sure nothing went boom. Anyway, investigators further reported discovering additional firearm components, illegal drugs, and electronic devices suspected of containing criminal evidence. Officials emphasized that the suspects' activities created a considerable potential for big harm. Needless to say, both Nasirs are currently in the Salt Lake County Jail, and they're going to be probably going to federal custody. And the older Nasir, he's going to be lucky if he gets out of prison, assuming he is convicted, because everybody's given the presumption of innocence. Next, remember the Courtney Clenney murder case? I know it seems like it's been going on for quite a while, but her attorneys have submitted a motion seeking to dismiss all of the charges against her. You may say, Scott, why? Well, the young and now former OnlyFans woman faces accusations of second-degree murder involving a weapon in connection with the fatal stabbing of her then-boyfriend, Christian Obumseli, on April 3rd in 2022, amid a little domestic dispute in their luxury apartment there in Miami. Anyway, Clenney, known professionally as an OnlyFans content creator under the alias Courtney Taylor, maintains that her actions were all in self-defense. Now, some court filings say that the defense contends that the state prosecutors improperly obtained confidential material belonging to the defense team. Anyway, these materials reportedly detailed the comprehensive strategy of her defense, which the prosecution had no legitimate access to. The filing further asserts that the accessed information extended beyond the relevant investigative period, incorporating data from the iCloud accounts from Clenney's parents, Kim and Deborah Clenney, that date back 17 months before Obumseli's death. Additionally, the motion argues that prosecutors viewed protected attorney-client communications. These include exchanges in a group message thread named Team Courtney, which involved attorney Frank Prieto and Sabrina Puglisi, their paralegal, an investigator, the defendant herself prior to arrest, and her parents. That's going to be the problem. Anyway, the communications occurring after the detention covered topics such as potential witness statements, defense experts, financial matters, and strategic analysis of the case. So earlier in the year, Clenney's legal team requested the disqualification of the entire Miami-Dade State Attorney's Office. This followed the resignation of the lead prosecutor, who had reportedly examined and distributed a privileged defense document entitled Courtney's Checklist of Things to Do. Privileged document. The current motion also accuses the prosecution of a Brady violation for withholding information about a key witness, a guy by the name of Arthur Cupp, a resident of the same building as both Clenney and Obumseli. Cupp informed arriving officers that he had observed Obumseli physically assaulting Clenney in the days preceding the incident. Furthermore, the defense alleges a Youngblood violation, claiming that potentially exculpatory evidence was destroyed without disclosure. Now, this pertains to photographs captured by civilian witness Danny DeValier, who was the initial responder to Clenney's 911 call on the night of Obumseli's death. Now, DeValier, in his deposition, reported that responding officers instructed him to erase all images and recordings of the scene prior to the arrival of emergency personnel and law enforcement. The defense argues that these materials could have provided critical support, including documentation of Clenney's initial statement upon assistance arriving, unaltered depictions of the environment before official intervention, and details of blood patterns that might bolster their position. So a Youngblood violation refers to a breach of a criminal defendant's due process right under the 14th Amendment of obviously the United States Constitution, stemming from the government's failure to preserve potentially exculpatory evidence. This concept originates from a United States Supreme Court case, Arizona v. Youngblood, which established that such a failure constitutes a constitutional violation, but you have to be able to show the government acted in bad faith. So in that case, the defendant was accused of child molestation and related offenses. Law enforcement collected semen samples from the victim's clothing, but failed to refrigerate the items, leading to the deterioration of the sample. This prevented timely testing that might have exonerated the defendant. Now, although the Arizona Appellate Court initially reversed the conviction on due process grounds, the Supreme Court reversed that decision, emphasizing that the need for proof of bad faith in evidence preservation failures. So, like I said, they must establish that they demonstrated that the evidence in question was potentially useful to the defense, that it was exculpatory, and that the government failed to preserve it, but the failure resulted from bad faith on the part of law enforcement or the prosecution, such as an intentional destruction to hinder the defense rather than mere negligence, oversight, or frankly, incompetence. So if there's no bad faith, no due process violation occurs, even if the evidence might have aided the defendant. So that's where it always gets tricky on a Youngblood. You can say, yeah, you failed to test it, you failed to preserve it properly, but you have to show bad faith, which is very tough because usually the prosecutors say, we did nothing to bad faith. We're just stupid. We're incompetent. And we wish we'd had that evidence just as much as the defense did. And so usually they go nowhere. So you may say, because you're a total CrimeTalk aficionado, what's the distinction from a Youngblood violation from a Brady violation, which involves the prosecution's suppression of known exculpatory evidence? So in a Brady case, bad faith is not required for a violation. The focus on the materiality of the withheld information is. So Youngblood specifically addresses the destruction or non-preservation of evidence that is not yet confirmed as exculpatory. So how does this affect our young star? Well, probably not. Okay. Now I understand because remember, the parents were charged in this as well. And that's where a lot of the information came from, as I recall, from the phones and these text messages. Now, had those phone messages been just between the attorneys and the investigator and the paralegal and the defendant, yes, prosecution probably is not going to get to use them. But when you include somebody who's not part of the attorney-client privilege team, i.e. the parents, you effectively waive the attorney-client privilege. And so I think the defense probably going to lose on that. This comes up all the time in the practice of law. Defendant goes and hires an attorney, but somebody else is paying for it, and it's mom or it's sister or whatever, and they all want to know what's going on. And you have to tell them, I can't really talk to you about this because it's a waiver of attorney-client privilege. Now what he tells you, the defendant tells family and friends they can do whatever they want, but it's certainly against any attorney's advice to do so. And it always becomes a pushing match, and you have to advise the client, listen, regardless of who pays, the defendant is the client. But if you allow non-legal, defense team people in, there's no attorney-client privilege to those communications. And so when you include everybody on that text message that's not part of the team, I don't know. I think the defense, I get why they're filing the motion. I would file it too. But the reality of it is it waives privilege. Next on the docket, a guy's been in custody for 7 years. Trial was supposed to start today, but it's going up on appeal. And so the defense says, hey, set my people free. So a judge in New Jersey on Friday denied a motion to release Paul Canero, the individual charged with 4 counts of murder from custody. Now, Canero contended that his prolonged detention exceeding 6 years without a trial infringed upon his constitutional right to a speedy trial. So Canero, who's 58, faces allegations of murdering his brother, who was also his business associate, along with the brother's family in Colts Neck, New Jersey, in 2018. Now, the trial was originally scheduled to commence on Monday, today, but was postponed last week pending an appellate review. But during the Friday hearing, the presiding judge, Judge Mark Lemieux, let Canero's legal team argue that the prosecution had failed to meet a September 14th deadline for initiating the trial under the speedy trial provisions, necessitating his release and charges dismissed. Anyway, the defense attorneys say that the injustice of detaining an individual for nearly 7 years without affording them a trial opportunity is an injustice, they argue. The delay stems from a decision by the New Jersey Supreme Court issued just prior to the planned jury selection on September 8th to consider the prosecutor's appeal regarding the denial of admissibility of DVR video evidence. Now, the prosecutor maintained that the speedy trial timeline should be suspended during the appellate process, and he affirmed that his office was fully prepared for trial and attributed the postponement to circumstances beyond their control, noting that the appellate court's acceptance of the case was unforeseen, and normally the trial court loses jurisdiction when the appellate courts take up an issue on any case, even if it's pre-trial, and speedy trial goes away. But hey, New Jersey, they're going to figure it out. Anyway, the prosecutor stated that jurisdiction over the matter had shifted, questioning whether the state bore responsibility simply for pursuing and obtaining an appeal. The judge focused on the legal definition of being trial ready, a criterion prosecutors must satisfy to justify and extended the speedy trial period. He acknowledged that both parties had been prepared to proceed as recently as the prior Wednesday, but inquired about the current status. Now, Canero is accused of fatally shooting his brother, Keith, shooting and stabbing Keith's wife, Jennifer, and stabbing their children, who were ages 11 and 8, back in November of 2018. Police allege he subsequently ignited a fire at the family's $1.5 million residence in Colts Neck to conceal the crime. Anyway, Mr. Canero has obviously entered pleas of not guilty. Jury selection is now scheduled to begin on January 5th. Speedy trial. It's nice and easy. From the day you say not guilty, here, it's 6 months. Federal, if you're in custody, you get 70 days. Of course, it usually gets extended for various things. it gets real weird and tricky when appellate courts come in. I think the prosecution will prevail on this because think about it. If you have, and normally when this type of issue comes up, just like this, there was exclusion of some evidence by the judge and the prosecutors appealed. Everybody needs to know what decision the appellate courts are going to make, whether that evidence comes in or not. You're not going to do the trial and then wait. Oh, we could have had that evidence again. No, it didn't happen. So I think the prosecution is going to prevail on that as well. Next on the docket, a Resident Evil has-been turns road rage into his own personal zombie apocalypse. So, well, isn't this just the pinnacle of celebrity behavior? A fading New Jersey performer, famous mostly for lending his mug to the Resident Evil games, now faces attempted murder charges after allegedly blasting away at a fellow motorist in a fit on a freeway fury that hilariously triggered a full campus shutdown at a local university. So Ernest Wesley Hines, the 48-year-old beacon of calm, apparently decided to channel his inner action hero last Thursday by slicing in front of a woman trying to merge at a stoplight, per the arrest report. Anyway, in no time flat, Hines allegedly hopped out of his ride to unleash a torrent of profanities on the terrified lady stuck behind him, topping it off with death threats because, that's how mature adults handle traffic situations. Anyway, as they neared the light, the guy screamed at her, stuck his arm out, and popped off a round, explained Captain Mark D'Esposito from the Galloway Township Police Department. Anyway, the driver dialed up the police in a panic, claiming she'd taken a bullet to the face as Hind zoomed off straight towards the Stockton University turf. Because why not drag innocence into your drama? Anyway, by the time law enforcement showed up, our aspiring villain had vanished, but the victim, miraculously sporting just a graze on her schnoz, was alert enough to spill the beans on the direction and paint a picture of the pristine white Honda SUV. Using her spot-on intel, police hunted down the hothead driver that very day. Meanwhile, the Stockton University got a joy of a thrilling 3-hour lockdown while everyone played hide-and-seek with the fugitive motorist. Hines got slapped with cuffs at a nearby home and hit with attempted murder charges. He's cooling his heels in the Atlantic County lockup, awaiting a court date to beg that his bail is set. And a move that is just amazing levels of absurdity. The police opted to post his glossy promo pic online rather than the usual unflattering jail snapshot. This irritable imitator of stars hasn't graced any noteworthy gigs since a forgettable short flick dubbed The Soul of Blue Eye back in 2014. And in his brush with fame, he snagged nameless spot on The Sopranos and is mostly remembered for donating his facial features to a couple of Resident Evil titles. Just can't make this stuff up, ladies and gentlemen. I mean, seriously, what have we said? What have we said about traffic matters? Let it go. Let it go. Somebody cuts you off, let it go, right? Because let's say, for example, you have a gun. You hold it up. You show it to somebody. That could be menacing. That's a felony. Not good. You'll never be able to hold that gun again, ever. Let it go. It's not worth it. I've seen people lose their jobs, security clearances, go to prison because they wouldn't let it go when it came to a traffic matter. I get it. Things are a little different. Somebody gets out of their car, comes at you, they're holding a gun, then you can do it. Let it go if you can. Let it go if you can. Next on the docket, another teacher for you-know-what. In Boiling Spring, South Carolina, the Spartanburg County Sheriff's Office reported the arrest of an individual in connection with allegations of an improper relationship involving a teacher and a student. So on September 12th, police and school authorities informed parents about the reported inappropriate conduct at Boiling Springs High School and confirmed that an inquiry was in progress. We're looking into it, and by gosh, this isn't who we are. The typical standard stuff that every PR department in every school district puts out there when an allegation of a teacher-student misconduct. Anyway, the following day, on September 13th, the sheriff's office announced the apprehension of a teacher named Micah Langford, who faces 4 charges of sexual battery against a student. And then on September 14th, 4 more warrants for the same offense were issued, increasing the total charges to 8. Now, Mr. Lanford remains detained at the Spartansburg County Detention Center, where the judge refuses to grant him a bond on September 14th. Anyway, the sheriff says the investigation continues, and obviously if you had a student there, you may want to talk to your student and contact the police if something inappropriate happened. Next to the docket, this day in legal history, September 15th, 1787. And you may say, Scott, what is the significance of the Constitutional Convention taking place? And there were concerns and dissents over various provisions, including Senate terms, right? How long was senators going to be in office? Secrecy of House records and congressional powers to shape the final Constitution. Well, the significance is in 2 days, on September 17th, 1787, the U.S. Constitution will be signed, ladies and gentlemen. That's a big deal. And so these little things are being hashed out. And remember, September 17th, Constitution Day. I know it's a holiday that most people aren't aware about, but it's a day. No day off, no paid holiday, but it should be. Anyway, next, September 15th, 2008. Lehman Brothers Holdings files for Chapter 11 bankruptcy protection. Obviously, one of the largest in U.S. history. Oh, and by the way, you know, Lehman Brothers, the whole financial collapse, submortgage prime loans. Yep, those are the guys. Oh, and I guess I got ahead of myself. September 15th, 1963, members of the Ku Klux Klan bombed a predominantly African-American church in Birmingham, Alabama during the Civil Rights Movement. The blast at the 16th Street Baptist Church killed 4 young girls and injured 20 other people. Despite an investigation by the FBI, no one was charged with responsibility for the crimes until Robert Chambliss was convicted of murder in 1977. His accomplices, Thomas Blayton Jr. and Bobby Frank Cherry, were not tried and convicted until almost 25 years later. And then on this day, 1966, President Lyndon B. Johnson urges Congress to enact gun control legislation in response to a mass shooting, obviously influencing the future firearm regulation. See, ladies and gentlemen, nothing changes. Everyone is always trying to take other people's guns because what other people do with their guns. Those guns did not just jump up and shoot somebody. It's people with evil intent that do bad things with them. And then on this day in 1976, the United States ratifies the Convention on the Registration of Objects Launched into Outer Space, establishing legal frameworks for international space activities. Yes, there is actually a practice of law, in the area of practice of law of space law, ladies and gentlemen. On September 15th, 1981, the Senate Judiciary Committee unanimously approves Sandra Day O'Connor as the first female Supreme Court justice, who was obviously nominated by President Ronald Reagan. And on our quote of the day, it deals with self-incrimination. That's right, that right protected under the Fifth Amendment. The constitutional protections must not be interpreted in a hostile spirit. Too many, even those who should be better advised, view the privilege as a shelter for wrongdoers. They too readily assume that those who invoke it are either guilty of a crime or commit perjury in claiming the privilege. Such a view does scant honor to the patriots who sponsored the Bill of Rights as a condition to acceptance of the Constitution by ratifying states. The founders of the nation were not naive or discardful of the interests of justice. That's right, that was Justice Felix Frankfurter in Ullman v. U.S., a 1956 United States Supreme Court case. And then finally, our dumb criminal of the day. In a splashy mishap that's sure to make waves in the tour bus, a guy by the name of Tyler Caphart, a 39-year-old cameraman shadowing pop sensation Benson Boone, found himself in a bit of hot water, or should we say a puddle of it, after allegedly turning a Florida beach boutique into his personal restroom. Now, according to the police report, that on a sunny Thursday afternoon, Capehart sauntered into Clearwater's surf-style emporium, ascended to the upper level where he lingered suspiciously amid the apparel aisle, as captured on videotape. And once he departed the scene, a vigilant store manager discovered the garments and the flooring awash in an unwelcome liquid, rendering nearly $690 worth of merchandise unfit for sale and prompting Well, a call to the police. Well, when confronted by the police officers, the evidently tipsy Georgian confessed to indulging in booze and bud, but claimed a somewhat foggy memory regarding his impromptu indoor irrigation. Sporting a mugshot that's anything but picture perfect, Capehart was arrested on charges of mischievous mayhem and boozy bedlam, both misdemeanors, and shuttled to the local lockup. He posted a $650 bond for his freedom just in time to potentially rejoin Boone's American Heart World Tour before it flips into Tampa's Benchmark International Arena tomorrow. Now, though records peg him as Boone's direct hire, insiders clarify he's the shutterbug wizard behind the onstage visuals, earning a nod in the show's closing credits. Talk about a career that's gone down the drain. All right, ladies and gentlemen, that's all we have for today. I know it was a bit of a long show, but I hope you enjoyed it. Have a wonderful day. We'll see you tomorrow. And remember, the Constitution matters.